Шановні колеги, я маю честь запросити до слова нашого колегу з Німеччини, директора Інституту Макс Планка в місті Гамбург, професора Юргена Базедова, доктора юридичних наук, професора. Here you are, dear professor.
Dear Professor Majdanek, ladies and gentlemen, let me first thank the organizers for putting together this great conference in such a beautiful environment. I personally believe that the beauty of the environment somehow has an impact on the spirit of a conference. So this is really superb. A second preliminary remark relates to the initial speech of Chief Justice Romaniuk. He spoke about the case law of the European Court of Human Rights in Strasbourg. I shall speak about the Court of Justice of the European Union in Luxembourg. They do not only differ in location, but also in the method of interpretation, because the European Court of Human Rights has, as the only basis of its own case law, the European Convention on Human Rights, which is a very short one. And it simply puts limits to the sovereignty of the member states. So it's a kind of confinement. Whereas in the European Union, where the Court of Justice is the supreme organ of jurisdiction, there is an incredible mass of law, of statutes, of directives, of regulations. So the court cannot just confine itself to limiting the case law of the various member states. It has to deal with a positive interpretation of case law, of the statutes. You have the slides of my presentation in your folders, and just to give you a short survey, I shall speak about I shall give you some data about the Court of Justice. Then in a second part, I shall refer to the background of interpretation, which is partly in the national law of the member states and partly in public international law. A third part will outline the emancipation of the EU law in the case law of the Court of Justice, and then I shall come to the various methods of interpretation. My subject, I think, has a double interest for Ukrainian lawyers. The first one is that the association agreement requires the adjustment of Ukrainian law to EU standards in a great many areas, including fields of private law, such as consumer law, financial services, company law, labor law, competition law, and the law of intellectual property. Given the intention of the contracting parties to implement legal harmonization, it will be important for Ukrainian lawyers to take account of the case law of the European Court of Justice and to implement the methods of interpretation of EU law. That is the practical side of my paper. From a more academic perspective, the methods of interpretation applied by the European Court of Justice to a certain extent reflect hermeneutical traditions of Western European countries that appear to differ from the more positivistic approach of courts in the former Soviet Union and its successor states. It is also in this regard that a closer look at the Court of Justice's methods of interpretation is worthwhile. So let me turn to the first, to the next slide. Yes. The Court of Justice of the EU consists of the Court of Justice in the strict sense and the General Court. My paper focuses on the former, on the Court of Justice in the strict sense. This court currently consists of 28 judges, one from each member state. The court is assisted by advocates general, currently 11 in number, whose opinions summarize the facts of a case, the relevant union law and national law, the state of case law, an analysis discussing the issues raised by the pending case, and they draw conclusions that are often followed by the Court of Justice. The court is sitting in chambers of 3 judges, 5 judges, or 14 judges, that is the Grand Chamber. The opinions and the judgments are published in all official languages of the EU on the website, which is indicated here, curiaeuropa.eu. And by the way, this website has a very good search form. Among the 23 official languages, there are 6 Slavonic languages, with Bulgarian using even Cyrillic letters that may be more accessible for Ukrainian lawyers than the other official languages. The jurisdiction of the Court of Justice is determined by a limited number of types of procedure regulated by Articles 258 of the Treaty on the Functioning of the European Union. They reflect the different functions of the Court of Justice. Initially, the court was conceived of as an international tribunal for disputes between the founding member states, as a constitutional court for solving disputes between various institutions of the Union, and as an administrative court dealing with the review of decisions of the European Commission by a court. Over time, however, the court has gradually adopted the role of a Supreme Court which harmonizes and unifies the interpretation of EU law by the various member states. And today it is even primarily responsible for this uniform application. The main vehicle for that kind of function is Article 267 of the Treaty on the Functioning of the European Union, which is called the referral procedure. In 2015, the court received 436 cases upon referrals submitted by national courts out of a total of more than 700 cases. So you can see that it's about 60% coming from the courts of member states. All courts and tribunals of member states, even the lowest courts, are entitled to submit preliminary questions on the meaning and validity of provisions of EU law to the Court of Justice. The courts of last instance, the final courts, even have a duty to do so. The questions are of an abstract nature, although submitted in the light of the facts of the pending case. But the questions are abstract. Likewise, the Court of Justice's replies are abstract answers to those questions. It is up to the national court to decide a pending case on the basis of the answer given by the Court of Justice, so that there is a referral and a referral back, and then the national court decides. Next slide, please. Yeah. When comparative lawyers from Western countries look at the interpretation of legal provisions in the post-Soviet world, they notice very soon the rather positivistic approach that still appears to prevail. I think Professor Kuznetsova has also referred to this. Conversely, scholars from the East often perceive the Western methodology as liberal and may even have difficulty to reconcile it with their understanding of the role of the courts. How can this divergence between the approaches to the interpretation of statutes be explained? While of ancient origin, legal positivism received a strong backing in the 19th century, when positivism prevailed in philosophy and generated the widespread belief in jurisprudence that the proper ordering of the society was a matter for intentional expression of the legislature. As a result, movements such as first in France, the École de l'exégèse, and later in Germany, the Begriffsjurisprudenz, predicated a strict interpretation of legislative texts. In the West, this was a transitory phenomenon. But in Marxist theory that evolved in the same period, legal positivism was tied up with the so-called mirror theory, which considered law as part of the superstructure of a society that simply mirrors the socio-economic basis. When this basis changed in the Russian Revolution, legislation became the expression of the will of the working class that required absolute compliance in the strictest way possible. Thus, legal positivism was a cornerstone of class struggle and cherished until the breakdown of the socialist regime and the dissolution of the Soviet Union. However, as legal thinking and methodology, unlike legislation, cannot be changed overnight, the tradition of legal positivism is still on the minds of many lawyers in Eastern Europe. In the West, we have observed already around 1900 a certain opening of the minds, and this became even stronger in the period after World War I. I cannot go into detail here. I just would like to continue with the next slide. As I said, the Court of Justice started as an international tribunal interpreting treaties. Therefore, rules on the interpretation of treaties were of particular significance from the very beginning. As you may know, these rules have been codified in the 1969 Vienna Convention on the Law of Treaties. And in fact, Articles 31 to 33 of this convention list a number of interpretive methods. While the convention has not been ratified by all states, there is unanimity that these provisions, 31 to 33, reflect customary international law. There is a trias of interpretive methods, which is usually abridged in English language by the words text, context, and purpose. Interpretation has to give primary weight to the text of a provision. It has to interpret it in the light of the context and of its purpose. it is interesting and perhaps significant that historic interpretation in the light of the travaux préparatoires of a treaty has only a secondary significance in Article 32. It's only of a subsidiary meaning. What is particularly important is also Article 33, the interpretation of texts drafted in multiple languages. I shall come back to that in a minute. Next slide, please. Now, this is the background in interpretive methodology in comparative law and in international law. The European Union, from the very beginning, or the European Court of Justice, rather tried to avoid any particular weight given to a national law. This was most clearly laid down already in the early case, Costa and Enel, a case coming from Italy, and by the way, submitted by a court of the lowest level. In this case, the Court of Justice made some more philosophical remarks about the creation of the Union, and it said, by contrast with ordinary international treaties, the EEC Treaty has created its own legal system, which became an integral part of the legal systems of the member states and which their courts are bound to apply. So it's what we usually call a sui generis system of law. The main reason given is that the community is of unlimited duration, that it has its own institutions, its own personality, its own legal capacity, and the capacity of representation on the international plane. As a consequence, the Court of Justice said already in 1964, the legal system of the Union is neither to be understood by any national system of law, nor is it part of international law. It is something in between. This means that the court had free hand to develop principles of interpretation of a sui generis nature. Next slide, please. A first example is the so-called effet utile, which is an interpretation standard widely used by the Court of Justice. The principle of effective interpretation has not been laid down in Article 31 of the Vienna Convention on the Convention on the Law of Treaties, but it is said to be included in the teleological interpretation and or in the reference of that provision to the good faith principle. Anyway, it has been acknowledged where a provision is open to several interpretations, the one that best enables the treaty to have the intended effects should prevail. That is recognized in public international law. The Court of Justice has made use of it in various contexts. I cannot give you all the details here, but for example, the court was asked whether a member state which has not transposed a directive of the European Union into national law may be liable vis-à-vis the third persons, the private individuals, for this breach of EU law. The Court of Justice said in a first decision, we have such a state liability at the level of the single member states. We also have it at the level of the Union, if the Union does not comply with its own law. But there is no law dealing with the liability of member states for breach of Union law. It then continued that this is a matter of full effectiveness, and that the full effectiveness, the effet utile of the Union can only be safeguarded, can only be ensured if such a liability exists. So this was really a creation, or you may say a filling of a gap, but you could also say the creation of a rule that is nowhere present in the written law of the Union. I do not go into further details. You can find that in the manuscript, which one day will be published. Another example for this emancipation of Union law from national law and from public international law is the development of general principles of law by the European Court of Justice. There is an express reference to general principles in Article 340, but with a very limited scope. The Court of Justice has spelled out in numerous provisions that general principles are a guideline for the law of the Union, and these general principles are of a very different nature. Please, next slide. While I've talked about the consequences of the emancipation for the interpretation of Union law so far, there are also consequences for the interpretation of national law. The court has in fact pointed out that national courts are required to interpret their national law in the light of the wording and the purpose of the directive in question or of the law of the Union in general in order to achieve its result. This is a first step to change the instrument of the directive from something which is only binding on the member states, on the governments of the member states, to a source of law which has to be complied with by the jurisdictions, by the courts as well. So you will be in Ukraine in the situation that, I don't know, several hundreds of directives will be transposed into Ukrainian law in the next years. It follows from this decision von Colson and Kaman and other decisions of the Court of Justice that the single courts are bound to interpret the national provisions as much as possible in the light of the directive, which is the basis of this national provision. There are some limits where the wording of the national text does not allow to go beyond a certain interpretation. Then there is no obligation of interpretation contra lege. Please, the next slide, please. Since we have heard before the coffee break something about precedent, I should perhaps add a word about precedent in the law of the European Union. As it was pointed out, even in common law countries, the rule of precedent is today rather considered as being a persuasive rule. A precedent should be followed unless there is some basic change in circumstances also. I think this can be said for all European jurisdictions. If you look into judgments of the German Federal Court, you will find that they usually cite previous decisions on the same case. The French Cour de Cassation, which usually gives its judgments in a very succinct manner, is equally based on the convincing or persuasive role of precedent, and so on. And quite the same in the European Court of Justice. It is the task of the Advocate General in such a case to explain the state of union law, and in particular the state of the case law of the European Court of Justice on a given matter. So from this perspective, I think it is no longer correct to distinguish basically between common law jurisdictions and civil law jurisdictions. This is simply no longer true when it comes to the interpretation of statutes. The methods of interpretation used by the Court of Justice have much in common with the methods known from national legal systems and from the law of treaties, which I have outlined before. The starting point is always the literal or textual interpretation, which is of course burdened by the use of multiple languages in EU acts. There is the first regulation ever of the European Court of Justice, of the European Union, which lay down the official language regime of the court, but it does not say anything about the interpretive use or value of the various languages. In this respect, it is good to keep in mind, as it was often said by the Court of Justice, that the wording used in one language version of a provision of EU law cannot serve as the sole basis for the interpretation of that provision or be made to override the other language versions. Provisions of EU law must be interpreted and applied uniformly in the light of the versions existing in all EU languages. Where there is a divergence between the various language versions of an EU legislative text, the provision in question must be interpreted by reference to the general scheme and the purpose of the rules of which it forms part." Unquote. Thus, in accordance with what Article 33 of the Vienna Convention on the Law of Treaty lays down, the interpreter is referred to other interpretive methods in case of divergence of the languages. And you sometimes find in the case law of the Court of Justice such references to various language versions. It is, by the way, the EU texts do not always use the language, the wording that is common in the respective jurisdiction. For example, if you have something in English, you should not believe that the understanding of such a word, of such a term, by an English lawyer is decisive. That's not the case. The Court of Justice will never proceed this way. The systematic interpretation is, oh, please, could you go on to the next slide? Yeah. The systematic or contextual interpretation can have different meanings. There is the reference to the microsystem of a legislative act, for example, on the law of, I don't know, product liability. There is also the possibility of referring to the system of the whole area of the law, private law. And there is finally the possibility of referring to EU law in general. We find elements for all three cases, for all three versions. But I would say that it is still the prevailing view that the systematic interpretation refers to the system of a single act. The most important method used by the European Court of Justice is certainly the teleological or purpose-driven interpretation. The problem is, however, that it is not always possible to identify a single purpose of a provision. Very often there are purposes to both sides. An example is consumer protection. You have very long provisions. They serve, of course, consumer protection. But on the other hand, they also provide a precise framework for the business side. And this somehow limits the possibility of interpreting such a rule in the exclusive light of consumer protection. There are two other methods which have not been mentioned so far by me. There is the comparative interpretation. In fact, the Court of Justice sometimes makes use of comparative methods, more so the Advocates General than the Court of Justice. This is the next slide, please. Yeah, thank you. But there are cases such as this case, Simone Leitner, where the Advocate General, in a detailed analysis of the legal development, pointed out that the claim for compensation of a package tourist would not be confined to material damage, but also include pain and suffering and other forms of immaterial damage. What we hardly ever find in the case law of the Court of Justice is the economic interpretation under the heading of efficiency in microeconomic terms, or even sometimes in macroeconomic terms. We have such judgments at the national level, but I can identify very few arguments of this kind by the Court of Justice. One could even say that in the field of competition, which is inherently linked with economics, the Court of Justice more or less has refused to operate a purely economic analysis of European law. Could you go on to the next slide, please? Since we have several methods of interpretation, it is quite clear that depending on the method employed, you can arrive at different results of interpretation. It would be fine if we had a hierarchy, but there is no hierarchy. And I think for good reasons there is no hierarchy, because the various arguments have a different weight in the context of statutes which have just been enacted, or statutes which have been enacted decades ago. There are changes in the same way as we can say that the rule of precedent has a different meaning with regard to very old precedents and new precedents. We can say so also for statutes which have been enacted in a certain environment that is no longer present. So let me come to some conclusions. Next slide, please. The Court of Justice was established in the 1950s at a time when the standards of statutory interpretation at the national level had already abandoned the former positivistic approach. Textual, historical, systematic, and teleological interpretation coexisted and were applied without any clear ranking. The other tradition that influenced the court's practice was that of treaty interpretation. The court soon emancipated itself, characterizing EU law as an autonomous legal system. Its dynamic development was promoted by a dynamic interpretation through tools such as the effet utile or the general principles of law. In the court's practice, we find all four traditional interpretation methods. The textual interpretation is the starting point, but hardly ever the sole method. The large number of authentic languages carry the inherent risk of divergent meanings. Therefore, the court will usually refer to other interpretive aids as well, that is, systematic considerations, the historical background, and in particular the purpose of the provisions at issue. The multiple jurisdictions of the member states suggest to include comparative arguments more often than is actually done at present. It is noteworthy that economic considerations play a minor role, if any, in the court's practice. The various methods are employed in a mix that varies from case to case. In the perception of the law, there is no single correct answer to many issues, no single correct decision of many cases. Courts take decisions resulting from lines of argument which are more or less convincing. They aim at a correct decision, not necessarily at the correct decision. Their objective is to increase the convincing force of their reasoning for the greatest number of people possible. The persuasive power of arguments depends on several factors, in particular the pre-understanding and cultural background of the persons involved, the consistency of the various arguments, the procedure of reasoning and exchange of arguments preceding the decision. It's a discourse. The legal methods employed are part of that procedure and are meant to augment the persuasive force of a decision. For the Court of Justice, these considerations apply with particular emphasis. The multiple cultural backgrounds, socio-economic origins, and diverse legal educations of the judges have the consequence that the commonalities they share are much less than those of their colleagues sitting in any of the national Supreme Courts. The guidelines they have are the wording of the legislative acts of the Union and its constitutional orientations, the basic freedoms and competition constituting the internal market, the rule of law, the fundamental rights. The law of the Union, as interpreted by the Court of Justice, must evolve in this framework. Thank you very much.
Щиро дякую професору Базедову за надзвичайно цікаву доповідь з огляду на те, що угода про асоціацію між Україною та Європейським Союзом певні підстави дають нам розглядати Європейський суд справедливості як, з одного боку, джерело чи різновид м'якого права, але з іншого боку є положення угоди про асоціацію, які вимагають Україну дотримуватися тих чи інших положень цієї угоди, виходячи з того, як тлумачаться ті чи інші поняття саме в Європейському Союзі. Тому мені здається, що на сьогодні ми для себе не визначилися, очевидно, яке ж місце судової практики Європейського суду справедливості в системі джерел права України. З огляду на це доповідь професора Базедова є надзвичайно актуальною з тим, щоб зрозуміти основні підходи, тобто методологію тлумачення, застосування європейського права. Дякую.